Okay, good afternoon or good morning, depending where you are in the country or the world. Thank you very much for joining for this webinar, COVID-19 Issues for the Affiliate Marketing Industry. My name is Gary Keibel, and I'm a partner with the law firm of Davis & Gilbert in New York. My primary area of practice is in digital media, advertising, and privacy. So a big part of this conversation today is going to be about the Paycheck Protection Program and the CARES Act and some other financial areas. Little disclaimer that those are not my primary areas, although my colleagues in my law firm are spending a tremendous amount of time working in those areas. So they've helped me put together some content for you. But little disclaimer there that I am not the expert when it comes to corporate and financial matters. Those are others in my firm. And again, this is meant to be high-level discussion. This is not legal advice for you personally. You should always speak to your own attorneys and financial advisors before taking or withholding from taking any steps. Also, my presentations, if any of you have ever attended, I've spoken at Think Tank and Affiliate Summit, my presentations tend to be light, enjoyable, humorous at times. This is not one of those presentations. Sorry, couldn't think of any good, Paycheck Protection Program cartoons to put into the presentation here. So sorry if it's a little dense, but hopefully I will give you some good information. And we'll probably use less than an hour to go through this. Okay, so what are the things we're going to talk about today? We're going to talk about the CARES Act from Congress, and specifically the PPP, the Paycheck Protection Program. Also, there's another part that people tend to overlook called the Economic Injury Disaster Loan. Then we're going to talk about some tax reform issues. And a lot of this came out of the original Family First Coronavirus Response Act, the FFCRA. And so we'll talk about that as well. Then we'll talk about some things not specifically in these laws, but that relate to dealing with COVID-19 response. So we'll talk about some labor and employment issues, and we'll talk about work from home cybersecurity concerns, since everyone's workforce for the most part is remote. Then if we have time, we might talk about the California Consumer Privacy Act, since that is certainly a very big issue that affects the affiliate marketing industry, whether or not we're dealing with COVID-19, but we'll see if we have time for that. And we may skip right to the end after that point and just go to any Q&A you might have, which I guess you can put in through the chat feature on Zoom, and then maybe Sam can read them to me, or hopefully I'll be able to pull them out myself. Okay, so the CARES Act. So the CARES Act is the Coronavirus Aid, Relief, and Economic Security Act, and it provides $2 trillion of aid in response to COVID-19. Now, most people are focused on the aid to small businesses, and that's what we're going to spend a lot of time talking about today, the $349 billion that was targeted through the Small Business Administration program. But this is a $2 trillion aid package and provides aids to much larger businesses, in addition to tax reform and employment benefits. So it's a very broad program intended to help all parts of the United States economy. We've all heard the bad news about the number of people filing for unemployment. It's over 22 million people in the past month, and all the horrible statistics that are coming out. For the moment, of course, leading to the side, the most important thing, people who are ill and loss of life, which is, of course, the most important. But we've seen on the economic side information about retail going down 8.7% in March, and that only accounts for 2 weeks of people staying home. I think in April, you're going to see numbers of about 20% or 30% retail going down. So the aid to small businesses, which is mostly through the Paycheck Protection Program. That was an expansion to an existing loan program through the SBA, the Small Business Administration's 7A loan program, which already exists to provide loans to certain qualified small businesses. So this Paycheck Protection Program added more money to that program and added new requirements. Specifically, it added $349 billion for loans under the PPP. The bad news is, as we sit here at 12:10 p.m. Eastern Time, news came out about less than an hour ago that the $349 billion is all gone. That doesn't mean it's gone into the bank accounts of all the applicants and companies. It means likely that it's been distributed to the banks and financial institutions who are then going to give it to their customers. So the federal government is done. They are out of this money, and it's in the hand of the financial institutions to process the applications that have come in through their customers. To be clear, the way that this money is appropriated to companies and to solo practitioners and others is that you apply through your bank or through your credit union or through your other financial institution. And that financial institution gets the money directly from the federal government. It is possible, and Congress is negotiating remotely right now with Treasury Secretary Mnuchin about additional money to put into this program. I suspect there will be additional money. It just depends upon the rules and who that money is going to be allocated to. But the $349 billion is gone. We suspect there will be more. The money is just intended to cover what they call the PPP coverage period. It's just to cover for payroll between February 15th and June 30th. It's not intended to be money to be used later in the year. So that's another reason why we expect that there will be an extension and more money allocated for this program. So we'll dig into the PPP in a little more detail on the next couple of slides. But if for some reason you didn't qualify for the PPP or that money ran out, there's another program called the Economic Injury Disaster Loan Expansion. So that provides loans of up to $2 million to cover economic injuries. And you could sometimes get a $10,000 loan advance through the EIDL within a day or two. And I have spoken to some clients who have gotten that money. A lot of what we're talking about, I'm giving you sort of the legal analysis. The vast majority of this is driven by your bank, by your financial institution. You may have seen that the federal government and the SBA put out a loan application for the PPP when the program was first announced. But banks then created their own application system in order to allow companies to apply. So the banks are really controlling how this process works. Then the last part of this slide there talks about a loan subsidy program, which the CARES Act appropriated an additional $17 billion to subsidize certain types of existing SBA loans. So you might have been under an existing program or qualify for an existing SBA program. They put a little additional money into those programs. So the biggest thing that folks ask is, all right, this all sounds wonderful. Am I qualified to get these PPP loans? So a business has to meet the SBA's employer revenue-based size standards. And these are standards that have already been in existence, but there were some tweaks with the current PPP program. First thing is that a business has to have a tangible net worth of not more than $15 million and average net income after federal income tax of not more than $5 million for 2 fiscal years. It applies to all types, or sorry, I should say it applies to many types of businesses, for-profit, not-for-profit, veteran, tribal organizations, as long as they don't employ more than 500 employees and the principal place of residence is in the U.S. There's been a lot of confusion about this. There are affiliate rules so that if you have multiple organizations within your holding company structure, they are aggregated in order to determine the 500 employee limitation. And there's been a lot of confusion over foreign affiliates, and especially if there's foreign management of the U.S. company. Realize that the intention here was to aid U.S. businesses, but the SBA has never excluded companies solely for the fact that they are affiliated with foreign entities. One other important thing is that when this program came out, they made very clear that you have to be engaged in legal business operations. Now, that may sound like a no-brainer, that of course everyone's operating a business that is a legal business. These loans are not intended to give loans to drug dealers. However, think about the cannabis industry. The cannabis industry is a very big and booming industry with medicinal marijuana available in 20 plus states and recreational available in about 12 states. But cannabis is illegal on the federal level. So there's a unique industry where they do not qualify for this program at all, because cannabis is a prohibited activity on the federal level. It violates the Controlled Substances Act. Having a cannabis dispensary from the federal government's point of view is no different than having a heroin dispensary. So there are some industries that have been excluded, and those who work with those industries. Sole proprietorships, independent contractors, and other eligible self-employed individuals can apply. And businesses in the accommodation and food services industry with more than one physical location, but not more than 500 per location, were able to apply. And we talked about the affiliate issue a little bit already. Okay, so other PPP eligibility requirements. So this went live recently, and you have to provide to your financial institution a lot of information about your organization. And again, your financial institution is determining the documentation that needs to be provided. It's not the federal government. And it's kind of a unique issue because the federal government has said to the financial institutions, we're going to back up these loans no matter what. We're not worried about verification. We need to get it out quickly, and we're going to back it up. But a lot of financial institutions were still nervous about fraud and verifying who these applicants are. And so they set up additional application procedures to try and root out any fraud and to verify that people are qualified to get these loans. Also, because of the high volume, many financial institutions will not work with you unless you are an existing customer. So it's sometimes hard to find a financial institution that's willing to work with you. Things that are not PPP requirements, which are usually requirements of other types of loans, they're not looking at your ability to repay the loan. They're not looking for a personal guarantee. They're not looking for you to post collateral. It's really, intended to get the money out and get the money out quickly. So the loan terms. So the amount, how much money can you get? So the calculation is that you can get 2.5 times the average total monthly payroll costs during the 1 year before the loan, or calendar year 2019. So you take that 1 month, multiplied by 2.5, and that gives you the payroll cost. Thinking back to one of my slides earlier, where I said the PPP coverage period is February 15th through June, that gives you an idea about why they came up with 2.5. The interest rate on these loans is 1%, and the term is 2 years, and it could be used for operational and payroll related purposes. 75% must be used for payroll. So you can use the funds for rent and other operating costs, but 75% must be for payroll. And think about the reason for this. The reason for this program is to help businesses keep individuals employed. That's the primary purpose of this. Yes, another purpose is to help small businesses simply survive, but it's to help them survive by keeping their employees. There will be a deferment of the payment of interest, principal, and fees for 6 months, and any fees that are owed to the SBA, which are typical under different types of loan programs, are waived. So the best part about the PPP program, if you qualify and you get the money, is that there is loan forgiveness. You don't have to pay this back. So it's not really a loan. So borrowers are eligible for loan forgiveness in an amount equal to the payroll costs, the rent payments, utility payments, mortgage that they've actually paid in during the 8 weeks following the loan date, provided you've used 75% of the loan for payroll costs. If you use less than 75% of the loan for payroll costs, then there's a sliding scale about the forgiveness. It may be based on any reduction in the average number of full-time equivalent employees during the 8-week period, and it can be reduced by more than 25% during that period. So the loan forgiveness will not be reduced if employees are rehired and reinstated by June 30th. And we're waiting for a little bit more guidance on this, and we have this on this slide, but really it's almost on every slide. Businesses are waiting for more guidance on a lot of things from the Federal Reserve. I mean, this was done with such incredible speed, you know, to the credit to the federal government for being able to do this, but there were so many different wrinkles and so many different issues that have not yet been worked out. But again, focus on the intention of the program here. The intention of the program is to keep people employed. So we unfortunately already have 22 million filing for unemployment. We don't want to have more. We want people to be able to stay with their companies. That keeps the small businesses going, and that reduces the burden on state unemployment ranks. Okay, I talked about how this is all the $349 billion for small businesses. Not to be overlooked, about 75% of the CARES Act allocated money to other businesses and to large businesses. There was $25 billion for air travel, and early indications are that that is not anywhere near enough to help the airline industry because the travel has almost disappeared. $4 billion for cargo, $17 billion for businesses critical to maintaining national security, $454 billion to eligible businesses such as states, municipalities, and other programs through the Federal Reserve, and it's available to U.S. organized businesses with significant operations in the U.S. Again, all these large entities. There were some restrictions. Again, this happened very quickly, but they did put in some controls to prevent abuse. Companies that get these loans, these very large companies, are not allowed to use it for stock buybacks. Because think about that, if you're a massive, large company and you're able to get some of these billions of dollars and your stock has gone down 50%, that would be a great time to buy back your stock, realizing that it's going to appreciate once the economy turns around. So that is prohibited. It's also prohibited for large entities to use this money to pay dividends. They can't just get this money from the federal government and then send a nice check to all their shareholders. And it can't be used for employee and officer compensation severance packages. So they can't give great golden parachutes to senior C-suite people who are leaving the organization. There were other restrictions, which we don't have on the slide here. One of the unique ones is that they prohibited this money from being used by the businesses or family businesses of people in the executive branch or legislative branch. And that was clearly to prevent the president from using this for his own hotel and real estate businesses. There's also tax reform and relief. One of the big things that's not on there today is February 16th. Don't worry if you didn't file your taxes yesterday, because they've been delayed for a couple of months to give people more time to deal with this. And also the IRS does not want to deal with all these returns coming in on April 15th. They've got other things to worry about. So another part of the reform bill here was the tax relief. So for certain companies affected by COVID-19, there's an employer credit of 50% of qualified wages that are paid to affected employees, which is creditable against your employment taxes. But there's no double dipping here. If you went out and got the SBA loan, you can't also say, oh, great, let me also take this employer tax credit. Again, the intention here is to keep your employees and small businesses employed. They don't want businesses taking advantage and double dipping here. There's also a deferral of employment taxes and deposits. So there was a deferral of employer side Social Security taxes and certain deposits related to unemployment and other employee insurance funds until December 31st, 2021. So they wanted to allow businesses to keep money in their bank accounts so they're not being drained. Because if you're a small business, you've got your employee costs, you've got your benefit costs, maybe you've got rent and other things that are due. and trying to give some relief to those small businesses so that they're not draining what little funds they have when income is unfortunately not coming in. Other tax reforms and relief. Business interest limitation is a limitation. The limitation on the deductible business interest has increased from 30% to 50% for last year and for this year. And there were changes to the net operating loss calculations. So they eased that temporarily to allow full deduction and a 5-year carryback for the past 3 years. Again, trying to find ways to allow businesses to keep some more money in their pockets, but not allowing for too much abuse. And there was a correction to the Tax Cut and Jobs Act to allow write-offs for certain real estate capital improvements. Although this is where things are colliding a lot and things are not always working properly, because that is certainly a nice write-off for real estate capital improvements. However, a lot of construction has been deemed non-essential by state stay-at-home orders. So if you're doing some capital improvements on your business property, those projects may need to be suspended while there are stay-at-home orders, and you're not allowed to continue that construction, so you're not really going to be able to get this tax write-off if the construction's not happening. But this was intended to help those in the hospitality industry, because the hospitality industry is always doing improvements on hotels and restaurants and vacation properties. And so they wanted to encourage that to continue, but you have to balance that against any stay-at-home orders in your state. Employment benefit relief. So they also expanded eligibility for unemployment benefits, as many of you well know. And the federal pandemic unemployment insurance added an additional $600 per week for those who are unemployed through July 31st, 2020. So if you are applying for unemployment, and as we know, over 22 million Americans have already applied, there's an additional $600 per week. So the idea is to try to keep people whole so they don't fall too far behind and fall into poverty. It's an additional 13 weeks of unemployment benefits after the traditional period has run out. So kind of going back in time, before the CARES Act, this all really started from the Family First Coronavirus Response Act, the FFCRA. And this was a sort of expansion of the Family Medical Leave Act, because they realized that there were people who had to stay home because they were either sick or they had to care for a sick employee or, a sick relative or family member. And they wanted to expand the Family and Medical Leave Act, because typically these employees could leave, but they may not get compensation. They may not be getting paid. We wanted people to be able to have some income coming in. So they gave an expansion here to allow employers to pay not more than $200 a day for people who were taking emergency Family and Medical Leave Act. And there have been many people that have been taking advantage of that, so that companies do have to pay them, but they're being paid a different amount than what was happening prior to coronavirus. So another thing that has happened, and again, things are moving extremely fast. Earlier this week, the Federal Reserve announced a new and expanded program to help for lending, and it's called the Main Street Lending Program. And the idea is that that's going to support direct lending to certain small and medium-sized businesses, and it's going to utilize funding from the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act. And it's different here. This is an actual loan. These are not forgivable loans. These are real loans, which will have to be paid back. So who's an eligible borrower under the Main Street Lending Program? It's generally a U.S. business with up to 10,000 employees or up to $2.5 billion in annual revenues last year. This one is very, very new. We've gotten very little guidance from the Federal Reserve. They put out an FAQ earlier this week. I don't think anyone can get loans from this yet, but when it becomes operational, then there will be a way to do it. We understand that there's a minimum loan size of 1 million. So the idea is that these are supposed to be larger loans for larger organizations, And I think the maximum loan amount is going to be the lesser of $25 million, or an amount that, when added to the eligible borrower's existing outstanding and committed but undrawn debt, doesn't exceed 4 times the eligible borrower's 2019 earnings before interest, taxes, depreciation, amortization. These are also going to be unsecured loans. There's actually going to be a larger one that is that does require some collateral, but mostly is going to be unsecured loans. But the most important takeaway for you here is that this is an actual loan. This is not the PPP program, which is going to forgive these theoretical loans provided you use it for payroll. Okay, a couple of other issues here. So we've talked mostly about CARES Act, PPP, and other ways to get loans and other monies in this time of the COVID-19 virus. But there are other important COVID-19 issues to focus on during this time. And let's look at some on the labor and employment front. So on the labor and employment front, especially when this broke early, a lot of companies were thinking, how do I test employees or screen employees or visitors if I have a hospitality establishment and decide to allow them in or not allow them in? That has kind of gone to the wayside as most states have stay-at-home orders. But I think this is really going to come back in a big way once the economy starts to open up, because then there's going to be a lot of talk about screening people and allowing certain people back into the work environment or the hospitality environment and setting up rules. And the states are talking about issuing rules to help with this. But some of the things that we've been hearing from our clients early on in March when this happened was testing. Could I force an employee to let me take their temperature before they walk into the office? And the guidance was generally, yes, you can do that. There are restrictions on the Americans with Disabilities Act. You would not want, if someone had a high temperature, to blast that person's name out to the entire company, unless there was a health and safety reason to notify people. You would want to keep that information private, keep it confidential, and only use it as necessary. And a lot of times clients would ask about HIPAA. Is there a HIPAA concern here? Not really, because HIPAA applies to covered entities that collect protected health information. So it applies to hospitals and healthcare providers and medical insurance providers when they're collecting protected health information. It doesn't apply to just a company that is seeing if their employee has a fever or not. But a big part of this is establishing policies about what information you ask from employees, how that information is disseminated, and how that information is kept secure. Think about this. If the receptionist at the front entrance to your business is the one taking people's temperatures, he or she may not know generally where to store that information. Should they keep it on just a pad of paper on their desk? Should it be logged into a certain database? Who's going to have access to this information? Again, you want to have policies and procedures to keep that information secure. Then work from home cybersecurity issues. So everyone is working from home these days. And we've always had people working from home at different times, but there are more security risks. And I put up on the screen here a screenshot of an alert that we put out. We issue alerts now and again. If you want to get on our lists for email alerts, just send me an email and I'll be sure that you're added to our lists. So with work from home, again, just like with the employment and labor issues, you want to have some policies here. So you want to be telling employees what is the authorized way to connect to the company's systems. There should be authorized means of connecting. Hopefully these are secure means, and employees should not be using others. So if you've decided that Zoom is the way to connect with the employees, then that should be the authorized way. One very big area is that you should be telling employees, use the company email system. I know you're at home. It's a little bit easier to work on your personal email. I think that should be a big, big no-no. You always want employees working through the company email system Because if employees are working through their personal email system, you as a company don't have access to those records. And God forbid something happens to this employee, you will not have access to important business information if it's not through the company's email system. So that's probably the number one work from home issue. Make sure employees use the company's email system. BYOD, we used to talk about bring your own device all the time. Are employees allowed to work on their own devices versus the company's devices? Well, now everybody's at home. So you need to think about what devices are authorized. Perhaps if you've issued employees laptops or iPads, you might want to reemphasize that even though they're at home, they have to work on those company-issued devices. Or are you going to make an exception? They're allowed to work on their own computers. Are you going to have standards for those computers? For instance, do you want every employee to prove to you they have antivirus software on their home computer or other security systems in place? Do you want them to certify that their home Wi-Fi network has a password so that it's secure? Think about these policies to keep your information secure. Phishing scams are on the rise, and that's going to create bigger issues because people are getting emails at home. They may not realize it's a phishing scam, and they're mingling their home and work on their home devices. Phishing scams are a big concern because that's where most security incidents arise from. Loss prevention, again, this is all about making sure you have control of your data. You're still a company, you're operating, you need to have control of all of your emails, your documents, any other materials need to be stored in the company system. They shouldn't be sitting on the C drive of people's home laptops, because then you as a company have lost control over your data. And incident response, if there's a breach and information has been exposed, just as you would if it was in the company's servers and everyone was sitting in their cubicles in their offices, you may have reporting obligations if there's a security incident. So you want to remind your employees and your personnel that they need to speak up. Like we say in New York City, in the New York City subway system, if you see something, say something. So important to tell employees that same thing happens at home. If little Johnny grabbed the laptop and ran down the street and gave it to the neighbor, you may need to tell your employee that I may have lost control of some company information. Okay, contracts. We get a lot of questions from this as well. Force majeure. Many people never heard that term until the COVID-19 virus outbreak. So force majeure, or an act of God. Many contracts will have at the back of the contract a lot of general sections which people tend to ignore, such as jurisdictions for disputes, assignment. There's often a clause called the force majeure clause, which actually means superior force. It's a Latin term. And what the force majeure clauses are generally designed for is that if there is some calamity and a party is not able to perform the contract, then they can be excused from the contract. For instance, you're supposed to hold a concert at a venue and the venue burns down. So then neither party has to perform. A number of things to be concerned about now that people are digging into these. Firstly, you need to look at what the clause actually says. It may very specifically spell out what a force majeure event is. Force majeure is not a legal concept, it's a contractual concept. So it only covers what the parties say it covers. So if your force majeure clause says a force majeure event is a fire, earthquake, or hurricane, then that's it. It doesn't cover pandemic. It doesn't cover stay-at-home orders. It doesn't cover a virus outbreak. So what that clause says is very, very important. Now, if a contract had no force majeure clause, there's sometimes still an argument, and there's a legal theory called frustration of purpose. Again, going to my example that there was a theater, you were going to hold a concert there, the theater burned down, obviously you can't perform. Frustration of purpose. There's been a lot of discussion in the industry about frustration of purpose when advertising just doesn't work. Think about if you had a contract for an ad on a billboard in Times Square. Well, the reason you bought that space is because tens of thousands of people walk by that sign every day. Now you may have 10 people walk by that sign. Is that a frustration of purpose? Does that mean you no longer have to comply with the contract? It's a very fact-specific analysis. And even if you get to the point that you say there's a force majeure event or frustration of purpose, I don't have to perform this contract anymore, there then may be an issue about, well, does that mean I get a refund of prepaid fees? Does that mean I just don't have to perform going forward? What does this really mean? It's very fact-specific. And what I would say is analyze what's in the contract and then try and negotiate with the other party. I would not threaten that I'm going to go to court and I'm going to get an injunction or require specific performance for many reasons. Firstly, courts are mostly shut down right now as well. They are only dealing with emergency issues. And courts are probably not going to look favorably on an advertiser or marketer coming in and saying, I need an injunction to prevent the other party from doing something or forcing the other party to do something so I can make money on my advertising revenue. They're probably not going to look favorably on that. They're focused on issues that are more critical. So yes, you go through your legal analysis of the contract, but I would say you try to work it out and you do the best that you can do. Okay. Next up, and I said we might talk about this, and I'll only talk about it for maybe less than 5 minutes, the California Consumer Privacy Act, the CCPA, because actually this is a very big thing that impacts the affiliate marketing industry. It's the nation's first comprehensive consumer privacy law. Why am I talking about it during a COVID-19 presentation? Well, because the law is on its way in, and I'm just zipping past some information. But as you can see there at the bottom, July 1st, 2020, enforcement begins of CCPA. You might say to yourself, wow, we're in the middle of this pandemic. I'm sure that's going to be delayed. The advertising industry trade associations heavily lobbied the California Attorney General, saying that the July 1 date should be put off because of the current pandemic. And the Attorney General said no. He said, nope, we're going to start enforcement as planned July 1, 2020. So you all need to bring yourself into compliance with the CCPA. We've put out probably a dozen alerts and email alerts on the CCPA because it's a very, very big issue. So compliance is still ongoing. Now, do I think on July 2nd, all these companies in the digital media space are going to be sued by the California Attorney General? No, I don't think that's likely. But enforcement can start July 1. I think the Attorney General will start looking at companies and industries that have done very little, and consumer complaints might be coming in. Some of you may have already received CCPA requests from California consumers to access their information or delete their information because the law is actually in effect right now. The law took effect on January 1st. It's just that the Attorney General was not going to enforce until July. What are the CCPA rights? It's that middle part there. Consumers have a right to know what information you've collected about them. Consumers have a right to have you delete that information. And consumers have the right to opt out of the sale of their personal information to other parties. Keep in mind, this is an opt-out law. It's not an opt-in law. But the law is very specific, requires a lot of disclosures that you may not already have in your privacy policy, and requires you to put in place procedures in order to honor these requests. Who does it apply for? And again, I'm going to skip through some of this pretty quickly. It applies to for-profit businesses that are doing business in the state of California, that collect consumers' personal information, and meet one of 3 or more thresholds: $25 million in annual gross revenue, processing 50,000 or more consumer records, or you derive 50% or more of your annual revenue from selling the personal information. And under the CCPA, if it applies to you, you are either what's called a business, a third party, or a service provider. A business is sort of the one that is determining how the information is being used. Think of them as the data owner. Skipping to the last one, a service provider is an entity that's providing services to the business, but there are rights under the CCPA for a service provider to keep and use the data for their own benefit. It's limited, but there are reasons. And a third party is someone other than that business who gets the data and is not using it for the benefit of the business. I don't need to read this whole slide to you. I can sum it up very, very quickly. The definition of personal information is incredibly broad. It's not just name and email address. It's IP address, persistent identifiers, tracking cookies, advertising IDs, mobile IDs. Those are all personal information. And a consumer has a right to know the categories you collect about them, the categories of sources, the purpose, the third parties for which you share it, and the actual pieces of information. If you get one of these requests, you have 45 days to process that request. Again, I said they have the right to opt out of the sale of their personal information. I already told you that the definition of personal information is incredibly broad. The definition of sale is incredibly broad. You may have seen on some websites a link at the bottom that says, do not sell my personal information or do not sell my personal info. That's a specific requirement under the law that if you meet the definition of making a sale, you have to have one of these links at the bottom of your page to allow consumers, again, just California consumers, to exercise their rights. Here's an example of Coke's website. Coca-Cola, you see it has do not sell my personal information. And when you click that, it deep links to their privacy policy and explains how you can exercise your rights. Damages, there's only a private right of action under CCPA if you have a security breach. There's not, that means individuals cannot sue you directly for any other type of violation. Just the Attorney General can bring claims against you and get statutory damages for violations. In the digital media and ad tech industry, the trade associations have come together to try and offer solutions just to deal with that opt-out of sale information. Because if there's a tag on a website collecting data to be used for behavioral targeting elsewhere, that data transmission is considered personal information because it's a persistent identifier. And if it's going to this other party to use for their own segments and retargeting, that's considered a sale of personal information. So the IAB put together their CCPA framework, which enables you to pass do not sell requests downstream to other ad tech providers. And that program is already live. You can sign up on the IAB website and join that program. And another trade association, the Digital Advertising Alliance, they have developed CCPA opt-out tools to allow people to exercise this right to opt out. Again, remember, this is an opt-out. It's not an opt-in, but your obligation is under CCPA, if you meet the definition of selling personal information of California consumers to a third party, you need to give them the ability to opt out through that link on your homepage. Google has a very unique program. Google has identified which of their products it's considered to be a sale of personal information and which of their products they're considered to be a service provider. It's called their Restricted Data Processing Program. And you can log into your portal with Google and turn on RDP for other products so that you can turn Google's receipt of data from a sale into a service provider relationship. The Attorney General had said last year, and I think this quote is still applicable, he says, "We will look kindly, given that we are an agency with limited resources, and will look kindly on those that demonstrate efforts to comply." And I think that's the big key here. With most CCPA compliance efforts, companies are having a hard time getting it perfect, especially in our current environment. So, but doing something, if you've done nothing, if your privacy policy looks like you've done nothing, I think you make yourself a target. So we've worked with clients on putting together compliance plans to determine their readiness, to come up with policies and procedures and update their policies for compliance, and to work on training and ongoing compliance for the organization. So what do you do now? And I'm nearly at the end of my presentation here. Definitely your privacy policy needs to be updated if CCPA applies to you. You need to understand your data, where it is internally, how you process it. Think about the service providers you work with. Do you have contracts that are up to date with them? And think about access requests. If you got a request from a California consumer asking for a copy of their data, do you have a process to respond to these requests? You may be updating your form agreements, and then the ad tech ecosystem, consider where you fit in. Are you a business? Are you a service provider? Are you a third party? New and pending federal legislation. We were expecting to see some federal privacy legislation. I don't think that's going to happen now at all. Between the COVID-19 situation and the general election in November, I don't think we're going to see federal privacy legislation this year. So in the absence of federal privacy legislation, we are all subject to this one sentence in the Federal Trade Commission Act, which regulates unfair or deceptive acts or practices. This is the one sentence that regulates the entirety of the advertising industry and privacy and data and content and marketing. It's to avoid acts that are deceptive or unfair. And with that, we've gotten to the end of the presentation. So the first question is, do payroll costs include healthcare benefits? So I'm going to try to give you the answer to the extent I know without checking with my colleagues. I know that there is a calculation for what is a fully loaded payroll costs. And there are certain items in this fully loaded payroll costs that are included and certain items that are excluded. And I would say maybe take a look on the SBA website, and they may tell you how to calculate what the fully loaded payroll costs are. The next question is, can we defer employment taxes before June 30th until we receive news of loan forgiveness? I believe, yes, you can. Again, I think you would want to check with your tax advisor to make sure that that's true. I think this may be especially true because there's a delay in getting the funds to people directly. So again, you definitely want to check with your tax advisor yourself and not rely just on this webinar. Next question, regarding the Main Street lending program, any indication what the interest rates will be? Very good question. I think the interest rate is going to be, and this is just some notes from one of my colleagues, an adjustable interest rate equal to the secured overnight financing rate, plus 250 to 400 basis points. So it is going to be real interest. It's not going to be like the PPP, which is 1%, but could be forgiven. This will have some real interest. Again, the Fed just announced this, I think April 9th is when they first gave their first indication of this Main Street business lending program. I think this is not getting enough press, because I think this could be really good for businesses, but it is a real loan, so you want to take a look at it very carefully. And I think that's the end of the list of questions. I'll just go ahead and wrap up and say thank you very much, everyone, for participating. And most importantly to everyone, stay home, stay safe, and I really hope you and your family stay healthy.